Yes,
Am I
you're
audible?
audible. Yeah.
Okay, okay. So first of all, I was welcoming Hetal. Thank you so much for joining us, Hetal. It's wonderful to have you with us this evening. And I must also compliment Varsha and Shipra and everybody to put together this particular session. We have a large number of people. I was surprised to see the interest in this particular session. And we'll be discussing the cross-border estate and the tax issues between India and particularly the UK. And in the coming week or so, we'll also have a separate session on US India, issues, because these are the two jurisdictions where we have maximum migration of, I would say, Indians, and many of them have become dual residents, or sometimes they are also in other jurisdictions as well. But these two jurisdictions have two peculiarities. One, that it is at an individual level, little higher level of tax. I believe Hetal will confirm to me that if you put together all the taxes, social security and otherwise, UK could go as high as up to almost 55-60%. And in the US, am I right? I think, and yeah, again, there is estate or inheritance tax in the UK. You have, you're going to talk about it a bit. And same way in the US, it's almost 40% at federal level and close to 10-12% at the state level, like California otherwise. And then in New York, it is like even at a city level. So there are three levels of income tax in a place like. So you can see the impact is very high. And again, taxation in India could also expose people to dual taxation. Fortunately, at this point in time, we do not have inheritance tax, but one cannot rule out a possibility that over a period of next 5 years, what is going to happen. We can discuss some of those things in our interaction. But one has to keep on the back of one's mind that, there could be possibility, although I don't think it will happen for 4 or 5 years, but at least I assume. Now in the US, the estate tax could be again upwards of 40%. Same way, I think UK is something like that, 40%. So I think this creates a maze of taxation, and especially for the mobile executives or those who are migrating for one reason or the other, are exposed to all these things, and it would be very helpful to have discussion on the subject. So maybe I don't want to take away all the time at this point in time, but Varsha, please take on, and once again welcome everybody. For this evening session. I think it's going to be very, very interesting. Thank you.
Thank you, Nishith bhai. So diving right in, Hetal, I think our audience is going to be very keen to understand what are the key tax and legal issues that families looking to either relocate to the UK, or individuals that are going abroad to the UK to study or work need to bear in mind when they're undertaking such relocation. So over to you, Hetal.
Thank you so much, and thank you for inviting me to speak today as well on this session. It's an area that I've been focusing on for the last 5 to 6 years in particular, specifically looking at global families, but those of Indian origin, and the sort of planning opportunities that exist whilst identifying the pitfalls around any relocation and asset diversification between the jurisdictions. Diving straight into the context of tax residency, and that's going to be the first sort of most important point for any family that's thinking about relocating, is actually in advance of that relocation, identifying from what point they might become tax resident in the UK. And Rosha, can I ask you to put up the case study that I've shared with you in that respect? I thought it'd be useful to just add some context, because when we talk about these theoretical matters, sometimes it's quite difficult to understand how this might relate to a specific family. So here we have the Patel family. Bear with me, it's just a simple scenario, but it does hopefully highlight ways in which a family can trigger tax residency, and sometimes unknowingly or without the right planning in place. So here we have a typical family where Mr. Patel is very actively involved in a trading business in India. Him and his wife have 2 children. One is an adult and one is a minor. Both have recently relocated to the UK for education purposes. And essentially, Mrs. Patel has been splitting her time between India and the UK in order to really settle the children into education in the UK. Now, when the UK assesses tax residency, for many years it was principally based on the number of days that you spend in the UK, as is the case in India. And whilst that remains the case as a starting point, the UK from Finance Act 2013 introduced a new way of assessing tax residency. And here we now focus on the ties that an individual has to the UK, as well as a combination with the day count that they spend. So there are 3 principal tests. One is that an individual could be automatically overseas resident, which won't really be in point for those relocating to the UK, so we'll skip over those. The next would be automatic UK residence, which similarly to India sort of mirrors that position that if someone spends more than 183 days in the UK, they would be tax resident. Or if someone arrives in the UK for full-time employment, or as a spouse of someone beginning full-time employment, then they would trigger automatic tax residency. But where most families really find themselves is this 3rd set of tests, which is called the sufficient ties test. Now, with sufficient ties, we look at 4 main areas. The first is family, second is accommodation, third is work, and 4th is UK presence. Now, these ties will determine when an individual becomes resident. So the more ties that someone has to the UK, the fewer days they could spend in the UK before triggering that tax residency. The family tie essentially in this context for Mrs. Patel could be triggered if Mr. Patel was tax resident in the UK, so spouse was tax resident, or by virtue of the minor child being tax resident in the UK and Mrs. Patel spending more than 60 days with the minor child in the UK in any given tax year. And just to identify that the tax year in the UK is not far off from the India tax year, and it goes from 6th of April to 5th of April the following year. The second tie would be an accommodation tie, and that's essentially when you have a home available to you in the UK. It doesn't mean that you have to own a home. It could be triggered just through an Airbnb lease, where essentially you have access to a home for more than 90 days of a year, and you spend at least 1 midnight there. Or, and this is the one that does catch people out, if it's a home of a close relative, if you spend more than 16 nights there, that can also trigger an accommodation tie. The third is a work tie. That's triggered if you spend more than 40 days working for more than 3 hours a day. So in this instance, Mrs. Patel might not trigger it, but Mr. Patel could. He's actively involved in the business in India. He's possibly visiting the UK, spending time with the children in the UK, but he'll still be running the business from the UK. And therefore, be it emails, calls, video calls, he could be working for more than 3 hours a day. So if that were to happen for more than 40 days, he would trigger something called the work tie. Last but not least, there is a UK presence tie. Now this is triggered if an individual spends more than 90 days, so roughly 3 months in a tax year, then for the following 2 tax years, they'll have a UK presence tie. So for instance, in this case, Mrs. Patel, it so happens, spent more than 3 months settling daughter into school in the prior tax year. So when I'm assessing her position for this tax year being 2020-21, she would have an accommodation tie on the basis of having a home available. She would have a family tie by virtue of her daughter, who is a minor child. She couldn't have the family tie based on son because he's an adult. And she would have a UK presence tie because she spent more than 90 days. Now, what this really means is that rather than the 183 days that we were looking at, the day count is brought right down to 91 days. So with 3 ties to the UK, anything more than 91 days in 2020-21 would trigger tax residency for Mrs. Patel. And that's something that a family might not anticipate because actually that's only 3 months of a tax year. Similarly, if she didn't have a family tie, but had an accommodation and a UK presence tie, she could spend up to 120 days. So the 3 thresholds that tend to be most important is a 90-day, a 120-day, and 183-day. So tax residency is very important because that will be the starting point of taxation in the UK. The moment you become tax resident, the starting point, as I say, is very much worldwide taxation on income and gains. However, for a family of Indian origin, domicile becomes very important to how they could be taxed in the UK. I'm not going to speak in detail about the concept of domicile, but I'm going to assume that Mr. and Mrs. Patel, being of Indian origin from an Indian parents themselves, they have an Indian domicile of origin. And what that means is when they arrive in the UK, essentially they retain that domicile of origin. And it's for HMRC in the UK to challenge that domicile status and say, actually, you've acquired a domicile of choice in the UK, and therefore we would consider you to be domiciled in the UK. Now, more often than not, a family relocating to the UK should be able to argue that they have a non-domicile status and that they have not acquired a domicile of choice in the UK. And the sort of typical things to bear in mind if you want to have that strong non-domicile position is to retain good ties back to India, which most families would continue to have, but secondly, to identify a fixed contingency upon which an individual might return to India. So typically what one might think about is when they retire. Another one for families traveling sort of older in age, slightly later in life, might be when grandchildren start full-time education. So these are just examples, but if the contingency was, if I win the lottery, I'll go back to India, then HMRC would say that's not a defined contingency with a real likelihood of happening, and therefore it's unlikely that they've retained their domicile of origin of India. Now, why is domicile so important to the tax environment in the UK? As Nishith quite rightly identified, the tax rates in the UK, are very high. So income tax goes up to 45%. Dividends are taxed at 38.1% at the highest rate. So it's fairly punitive when you have, like Mr. Patel has, a financial portfolio of investments, and just say he would be subject to worldwide taxation. The differential between India and the UK could lead to at least a marginal top up in tax in the UK if he were subject to worldwide taxation. So where domicile becomes really important is that if you are not domiciled in the UK, you have access to something called the remittance base of taxation. And this really is the opportunity to only pay tax on UK source income and gains and those foreign source income and gains that you actually physically remit to the UK. So this is essentially a planning opportunity for families. You would want to identify pots of something called clean capital, which are essentially funds that don't comprise of foreign income and gains. And typically the way to do this is to identify assets that you might liquidate and keep segregated as clean capital prior to arrival in the UK. In terms of the remittance base of taxation, there's no cost for the first 7 years, so it is free and it just has to be claimed on a tax return. And if the planning is done correctly, it creates quite a tax neutral environment in the UK, which is very advantageous for families that potentially might look at a liquidation event, for instance. So if Mr. Patel in a few years' time, within his sort of time frame in the UK, he could access the remittance base for 15 years. So within that 15-year period, if he were to think of selling the business, he may be able to benefit from a position where he only pays tax on the disposal in India and then is able to create this pool of funds offshore that isn't subject to tax in the UK. I say 15 years because an individual in the UK only has access to remittance basis for 15 years and thereafter becomes deemed domiciled in the UK. Now, where is deemed domiciled important? And touching on, as Nishith identified, inheritance tax. Inheritance tax is 40% in the UK, and a starting point for an individual that is UK resident but non-domiciled is that they'll only be exposed to inheritance tax on their UK situated assets. So initially, when a family arrives, it's not the biggest concern on someone's mind. But later on, if they have been resident for a number of years, at year 15, they will trigger a point where they become deemed domiciled in the UK for all tax purposes. And at that point, it would be the worldwide estate. So worldwide assets would be in the scope of inheritance tax if they don't undertake any planning And by planning, we're typically looking at offshore bonds or offshore trust structures, in particular discretionary trust structures, which are very useful. So the planning tools to really take away from a family that's thinking about relocation is pre-arrival planning. So that is identifying clean capital, which would be very useful to fund lifestyle in the UK. And this clean capital can, as I say, come to the UK free of taxation. If I don't plan for it and I were to earn a dividend or earn interest income that I then need to send to the UK in order to fund the lifestyle in the UK, I would be subject to an additional rate of taxation in the UK and have to go down the tax treaty analysis, which we'll come on to later in the session. Another sort of planning tool to really think about is potential husband-wife planning before family relocates, so that they can think about increasing the funds that they might be able to transfer outside of India, given the exchange control position and the capital controls in India, which I'll leave for Varsha and Shipra to discuss later on. In terms of planning around the children, in this scenario, the children are the beneficiaries of a Indian resident discretionary trust. These sort of trust structures can be very powerful tools for allowing for transfer of wealth outside of India. They could also be very useful in terms of funding lifestyle for the children, but really focusing on asset protection as well. And again, we'll talk a bit more about succession and asset protection further on in the session. So these are the sort of key points I would say from a relocation perspective. And I'll pass back to Varsha to take the session forward.
Thank you, Heather. That was really, really instructive and helpful. I think, like you pointed out correctly, India still follows a day count based system for assessing the tax residence of an individual. And while we we know of the typical 182-day requirement of staying in India during a financial year, there are additional considerations that need to be taken into account. So even in situations where an individual does not meet the 182-day requirement, there are other tests such as the 60 and 365-day requirement, which is if you stay in India for 60 days and you stay in India for 365 days in the preceding 4 financial years, you can still become a tax resident of India. That financial year for purposes of India is April 1 to March 31, not too far off from the UK, like you said. There are a few relaxations to the 60-day criterion, which is where an Indian citizen leaves as a crew member on an Indian ship, but also more commonly where a citizen or a person of Indian origin who's outside India comes to India for a visit, where this 60-day criterion is then read as a 182-day criterion. The recent Finance Act 2020 has made a few changes in this respect, where it's lowered the threshold to 120 days for individuals that have India-sourced income more than INR 15 lakhs in a year, which is quite a low amount. Another very interesting change that was brought about by the Finance Act 2020 is the inclusion of the concept of deemed residence in case of stateless persons. What it essentially says is that citizens of India who have more than 15 lakhs of income during a financial year, this 15 lakhs should be income that is sourced from India. Such an individual will be deemed to be a tax resident of India, where they are not taxable in another country due to their residence or domicile in that particular country. For individuals, we have yet another category under Indian law of residents that are not ordinarily resident. These individuals are then not subject to tax in India on their foreign sourced income, and hence avoid the global income taxation that is a consequence of being a tax resident under Indian laws. The requirements for someone being not ordinarily resident in India are a bit complicated, but essentially they require that the individual was a non-resident for 9 out of the previous 10 years, or for 729 days out of the previous 7 years. The concept of residence under Indian law also has to be looked at under foreign exchange laws, which is a little different from the way it's dealt with under Indian tax laws. Shipra, I'm going to ask you to jump in here and explain to us how the exchange control residence requirements are a little different from tax laws.
Sure. Thank you, Varsha. Happy to take up this concept of exchange control. So like other developing countries, India does have restrictions on the movement of foreign exchange. Typically, the restrictions are in terms of how much funds or Indian money can you move outside of India. In that context, just to talk about how residence sort of is determined in terms of exchange control regulations. So of course, similar to the tax day count test, there is a 182 day count test in case of determining residence under FEMA, which is the Foreign Exchange Management Act. However, how the FEMA test differs from the tax test is that in addition to or despite of the day count test, what we also need to look at is the intention of the party. So, I mean, just coming back to Hazel's slide here, if you look at Mrs. Patel, if she spends a significant time outside India, but we're able to establish a certain intention to spend time outside India for an uncertain period of time, she may be treated as, say, a FEMA non-resident from an Indian perspective. That doesn't really seem the case with Mrs. Patel. So, for example, if there is a business in India or a business outside India, or the person takes up employment outside India, that, you know, sort of gives us a basis of intention to stay outside India. Coming to the example of, say, the son and daughter who go to the UK to study in the UK, that I would think would satisfy the intention test, in that we know that, you know, two students are going to be studying in UK for a certain period of time. So in that case, I would say that the intention test is sort of fulfilled, and the son and daughter would be characterized as FEMA non-residents under Indian exchange control laws. Now, just now the consequence of becoming a non-resident under FEMA laws is that if the son and daughter here have certain domestic bank accounts, then these accounts need to be converted into something called an NRO account from an Indian FEMA perspective. And I think another consequence of this is that you no longer can freely sort of use your funds in your, as you would in your domestic Indian bank account. There is a certain limit on remittance of at least sums lying in an NRO account, and that limit is about USD 1 million per financial year. There are, of course, other ways of repatriating amounts, for example, amounts in the nature of current income like interest or dividends. These amounts can still be repatriated without sort of falling under the 1 million limit. So I thought these were concepts important to individuals from a exchange control perspective. Varsha, over to you, in case you have any further comments.
Thanks, Shipra, for explaining that. In resident tax laws and under exchange control laws, the concept of domicile also becomes relevant under Indian laws, although not for purposes of tax and exchange control as much. The concept becomes relevant for purposes of our succession laws, which are varied in our country and depend on a variety of factors. Domicile for these purposes is usually determined based on the place of the birth of the individual, which is usually by default taken to be their domicile of origin. And then you look at a variety of factors to determine whether there was a conscious act to change that domicile, which goes back to the similar concept that we discussed earlier, which is of the intention of the individual to actually stay long term in a particular place and change their domicile. The domicile of origin isn't always the place of birth of the individual. It depends on the applicable succession law. In the context of the Indian Succession Act, for example, the domicile of a legitimate child is supposed to be determined on the basis of the domicile of the father at the time of the birth of the child. So all of this just to say that there are a variety of factors to be considered to determine what an individual's residence plus domicile is, and they may not always be the same depending on what aspect we are looking at and what law we are actually analyzing things under. Coming from residence and domicile, quickly also talking about inheritance tax in the Indian context. Nishith Bhai mentioned that we've heard that it may be introduced back into Indian laws in the future. The last we had the inheritance tax in India was in 1985, and it was as high as 85% of the property value at the time. The reason for its abolition was that the costs of actually administrating and collecting the tax were far higher than the collections themselves. The same reason why the wealth tax was actually abolished in 2015. But every year we do hear rumors of the inheritance tax being introduced yet again. We are yet to hear something determinate from the government on this front, and we don't know when it might be introduced. So again, an additional factor to consider as a planning, point, because as we know, tax laws are changing quite rapidly the world over. So yeah, and another factor to be considered. Shipra, jumping over to you again, could you shed some light on what are the common planning tools and structures that we use in an India context, and how these are treated under Indian laws?
Sure. So in terms of succession and wealth planning, there are a few sort of different options that are used in an Indian context. There are, of course, wills that are used, or you could, or I think the most common structure, which is probably relevant even from a UK perspective, is a trust structure. I think the trust structure itself was also borrowed from the UK concept, but it differs from the UK concept of trust. To my understanding, is that in case of an Indian trust, the ownership in terms of both legal and beneficial ownership lies with the trustee. So just to explain how a trust would work, there is a settler who would basically settle or contribute funds or property into a trust. These properties will be held by the trustee of the trust for the benefit of the beneficiaries. So essentially, these are the three basic elements of a trust. An interesting sort of structure, because from an Indian perspective, at least, you can't really, trust is a very different animal in the sense that it's not really a body corporate, it's not really a legal entity or a person, right? So to that extent, trusts are very differently looked, both from a trust law perspective as well as from a tax perspective. So, I mean, just to jump into probably the different kinds of trust structures that are used in India, and how would they be taxed in India depending on the structure, just to throw some light on that. Essentially, based on Indian tax and trust law, we would divide trusts into 3 or 4 varieties. A trust can be revocable or irrevocable. In case of a revocable trust, the settler, who is the contributor of the trust property, he retains certain rights in relation to the distribution of the trust and in relation to the control over the assets of the trust. Now, why is it relevant from a tax perspective? It's because if you're looking at a revocable trust structure, the tax on the trust income is something that's going to be taxed at the hands of a settler. In a cross-border context, this would be relevant because if you're looking at forming a revocable trust, even in say the UK or in any foreign jurisdiction, and the settler of that trust is resident in India, then essentially, even if the beneficiaries of that trust are non-resident from an Indian perspective, and the settler itself is resident, the trust income is going to be taxed in India, not just on India sourced income, but on a worldwide income basis. So that's a risk you would that's a tax consequence of having a revocable trust from an Indian perspective. The other kind of trust is an irrevocable trust, which is essentially where the control and management of the trust assets vests with the trustee. The settler here sort of renounces all sorts of power over the assets in an irrevocable trust structure. Two other concepts that are relevant for trusts, at least from an Indian tax perspective, is whether the trust is a discretionary trust or a determinate trust. In case of a discretionary trust, the trustee retains discretion in terms of how distributions of income or corpus of the trust can be made to the beneficiaries. In a determinate trust, the trust deed itself would provide for the different allocations for each of the beneficiaries. Taxation would differ depending upon whether you're looking at a discretionary trust or a determinate trust. Basically, in case of a discretionary trust, we don't really know who the beneficiaries are, what is their income, slab rates and things like that. So the trustees tax qua the beneficiaries on a maximum marginal rate, which is basically, just simply put, it's the maximum rate that's applicable to the class of beneficiaries. In case of a determinate trust, since we are well aware of who the beneficiaries are in case of the particular trust, the trustee is taxed qua the beneficiaries, qua the income tax rates of the beneficiaries. I think just to again sort of put this in the context of an offshore structure, I think again there are various permutations and combinations that we can look at, and we'll probably discuss it when we're looking at a different sort of structure, different case study. We look at the different permutations and combinations. But essentially, just to put it simply, the taxation of trusts would differ in India depending upon whether the trustee is managed or controlled in India or abroad, whether the beneficiaries are located in India or outside, and so on and so forth. So I think we can move on to the nitty-gritties probably a little later. Over to you, Varsha.
Thanks, Shipra. That was really useful. Now we've, Hetal spoke about the UK side of things, and we spoke about the India side of things. And as would be clear, there is quite a bit of mismatch under the laws applicable to individuals that are looking to relocate. How are these differences then sought to be harmonized? We do have tax treaties between India and the UK. And the India-UK tax treaty does seek to provide some solutions to these issues. For instance, in a situation where an individual is regarded as a tax resident both under UK laws and under Indian laws, the India-UK tax treaty provides for a tiebreaker test. And the tiebreaker has a variety of stages that you can go through. The first being determining where the individual has a permanent home, then going to where the individual has a center of vital and economic interest, looking at where their habitual abode is, looking at where their nationality is, and then the last of all of these solutions, if we can't actually figure where their residence lies, is the competent authorities of both the countries can get together and decide. This is just on residence, though. There are other aspects that tax treaties cover, which is on allocation of double tax treaties. On allocation of taxing rights between countries. And the way that these are dealt with, apart from the allocation itself, is also through determination of tax credits and provision of tax credits by each country. While the treaty itself provides for foreign tax credit, the treaty does make these provisions applicable to the domestic law of both the UK and India. So, for instance, while India will provide foreign tax credit to an individual in respect of taxes paid in the UK, that provision of tax credit will ultimately be subject to Indian tax laws on provision of credits. The third aspect where going to tax treaties becomes really important and relevant, especially in the UK context, is in respect of fiscally transparent entities. And fiscally transparent entities such as trusts or partnerships, where the entity itself may not be regarded as a taxable entity for purposes of taxation in one country, but it's the ultimate holders of interests in those entities that are taxed in that country, are dealt with in a particular way under that country's tax laws, but that may not be mirrored by the other country. And then there's a question as to how does the tax treaty help us in determining who is going to be the taxable person there. Hetal, I'm going to call upon you here to please speak to us a little bit about these aspects in the UK context here.
Sure. Thank you, Varsha. Thank you, Shubha. Just to touch, before I go on to the treaty mismatch, 2 points that you mentioned where there's been recent change in India is one of deemed residents. And that's an interesting point because we have been considering that for various families who are UK tax resident and they are claiming the remittance base of taxation, so they are not actually paying tax on their foreign source income and gains. So income and gains arising in India are not physically taxed in the UK, but it's only because they're claiming the remittance basis of taxation. And at that point, what you really have to look at is whether or not that individual is liable to tax in the UK on that income. And leading sort of UK counsel on these matters and all of the analysis we've done on to opine on these matters, we would assert that actually you are liable to tax on that worldwide income and gains in the UK. It's only because you claim the remittance basis of taxation, and after year 7 of tax residency in the UK, you would have to pay £30,000 a year to be able to benefit from the remittance basis. So whilst it's not a physical tax necessarily as the income arises, one is considered to be liable to tax. And that's something I'm very happy to talk about in more detail separately or look at in more detail for specific cases. But it's important to identify that that's really a planning opportunity from a UK-India context, in that you're unlikely to be deemed resident in India only because you're not physically paying the tax on your Indian source income and gains in the UK, and you could still benefit from the non-resident rates in India, whilst benefiting from a zero, essentially, taxing environment for the first 15 years of tax residency in the UK. And the second point, just to touch on, which someone's asked a question about as well, is really with regards to trust residents. And in terms of a Indian resident trust, it's very important that you look at a trust that's established from an India perspective and a UK perspective, especially where a typical scenario might be Indian resident parents who establish a trust where some of the beneficiaries might be non-resident. Now, often what we see, and this is slightly more specific to India trusts in particular, is family members being trustees, which is not typical from a UK context, because typically in the UK context, we would seek to have corporate trustees in place for any offshore trust structures that a family would settle. And that's really because from a legal and beneficial perspective, it is the ownership of the trustees, so the assets are owned by the trustees. But from a UK standpoint, at least, a trust is considered to be resident where the trustees reside. So now, if I had a UK resident trustee, then I could risk making that Indian trust tax resident in the UK. And a UK trust is a quite inefficient vehicle. Trusts are very, very powerful from a UK standpoint for non-domiciled families, but particularly if they are in an offshore financial centre. So a trust that is established in a Jersey or Guernsey is a typical jurisdiction, or these are typical jurisdictions we would use for offshore trust structuring. And this is because income and gains would not be taxable, would not suffer tax in Jersey or Guernsey as they accrue within the trust structure, as they would in the UK or in India. Varsha, could I just ask you to go on to the second case study? So I'm going to try and give some more context to what broadly I want to speak about, which is succession. Thank you. And here I'll just set out the scenario, and then we'll try and pick on some of the points that have been discussed and raised, so around treaty points and succession and trust structuring, and where it can be really powerful and where it can really create some real added value from a decreasing tax exposure from a UK context, at least. So in this scenario, we have Mr. and Mrs. Agarwal. So they are the matriarch, patriarch of the family, and they reside in India. Their daughter married someone that was based in the UK and has been in the UK for about 14 years. They have children, 3 daughters, and they're all living as a family in the UK. Mr. and Mrs. Agarwal also have a son that resides in the US. And the reason for adding this sort of scenario is that this is a family situation that I do come across in practice quite often, where siblings are located in the US and the UK. As Nishith identified, the US and UK tend to be the jurisdictions where those of Indian origin tend to relocate when it comes to education, marriage, and business opportunities. So this is a scenario that we do come across. there are significant differences between the US and the UK. So one thing I'd like to flag is that what works from a US perspective is not necessarily going to work from a UK perspective. So taking specific advice for the UK nexus is quite important. I'm going to now focus on the daughter's scenario. Now, Mr. and Mr. Agarwal have significant assets in India. Now, if, God forbid, they were to pass away and they were to leave assets to the daughter who resides in the UK, and she had been resident for more than 15 years, at the point that she inherits any assets, she would become the beneficial owner of those assets that she inherits. At that point, if she's deemed domiciled in the UK, she has very little options when it comes to planning for those assets such that they are not exposed to inheritance tax in the UK. So just to set the scene, Mr. and Mrs. Agarwal's assets on being inherited by the daughter residing in the UK, at that point, there is no inheritance tax in the UK. It is for the daughter's estate that we're concerned about inheritance tax. And the reason why we do look to plan generations in advance is that there's a real opportunity where, from my perspective, there is a non-resident, non-domiciled individual in the picture, and that is my Mr. and Mrs. Agarwal residing in India. So daughter, to the extent that she has been in the UK for more than 15 years, has no option for structuring assets outside of the scope of inheritance tax. If, however, Mr. and Mrs. Agarwal don't leave assets to her outright, but were to settle the assets either in their lifetime or through a will, as Shipra identified, into a trust structure, then if that was a discretionary trust structure of which she was a discretionary beneficiary, then those assets would stay outside of her estate from an inheritance tax perspective in the UK in perpetuity. So future grandchildren, their children, this could be legacy wealth and really protected outside of UK inheritance tax, which is, as we said, 40% for anything above a very small nil rate band of £325,000 per person. Now, in this context, where this is particularly powerful is that there's a tax angle, but also there's an asset protection angle. And the UK courts, from a matrimonial perspective, are quite in favour of harmonising divorcing spouses. Now, in this context for the daughter, what the trust also adds is significant asset protection, so that the assets that she inherits, if they go via the trust, are not going to form or are unlikely to form part of the matrimonial assets that could be subject to division in the case of an unfortunate divorce. So these are two reasons why we would really significantly value a trust structure where the beneficiaries of the wealth are actually residing in the UK and are likely to be residing in the UK for the medium to long term. Where a trust structure is also going to be very powerful is for the daughter, if she has already received gifts from parents, if she has accumulated wealth of her own, any time up until year 15, she is able to establish what we would regard as an excluded property trust structure, which is essentially a discretionary trust. She could establish a trust structure herself, which could stay outside of her estate for inheritance tax purposes, but also it could mirror, from an income tax and capital gains tax perspective, what the remittance base is offered. So as I said, the remittance base is only available for 15 years, but if before 15 years you settle assets into a trust structure, then those assets, especially if they are located in a Jersey, Guernsey, etc., they could grow outside of the scope of UK income tax and capital gains tax. And that's where you really see some value for non-domiciliaries accruing for legacy wealth and really providing for future generations. So this is the type of planning where we look at opportunities for those relocating, but also those that have been in the UK for some time but will inherit significant wealth from their parents. Coming back to the treaty points that Rochelle touched on, there is a mismatch of taxable persons, and this is something that is a common problem that we face in two areas in particular, and one Rochelle identified quite rightly as the fiscally transparent entities, and that's particularly relevant for an LLP or partnership, which I understand in India would be taxable as a separate entity, and it's the LLP that is the taxpayer. Whereas in the UK, an LLP is completely transparent to, or a partnership is completely transparent to the individual partner. So if I am a partner in a partnership and that partnership disposes of an asset and creates a capital gain, that capital gain is assessable on me in line with my partnership share. Whereas in India, the gain may accrue to the partnership and you'll be assessable on a share of profits. So in this type of scenario, you have a mismatch where it's not possible to allocate necessarily the tax credit from the partnership in India to the taxpayer in the UK. So partnership context is one to be mindful of, and the other is very much with regards to trust structures. Now, if I have a trust established in India, the trust is often, especially in the case of a discretionary trust, it is the trust at trust level that is paying tax in India. Whereas in the UK, if I have a beneficiary of a trust, that beneficiary is taxable on a distribution made from the trust, and that distribution is essentially matched to relevant income and gains of the trust. Now, this means that I have a mismatch from the trust being the taxpayer and my beneficiaries being the trust taxpayer. So these are cases that we are looking at and coming across in terms of challenges. There are options for restructuring in a way that could mitigate some of these pitfalls, and something like a determinant trust working with a discretionary trust side by side could be quite useful, because in a determinant trust structure, I understand from an India perspective, one can argue that the trust is paying tax as a representative assessee of the beneficiary, and therefore my beneficial owner could be my taxpayer, who in the UK is the beneficiary of the trust. So these sort of treaty points are quite important. As far as she identified, there is a catch-all article in the UK-India Treaty, which essentially seeks to eliminate any form of double taxation. But it's important to note that if you are relying on any treaty positions, you do need to claim them on your tax return in the UK. And once you become tax resident, and if you do have Indian source income and gains, you do have a filing requirement in the UK. So you must file that tax return in order to claim either the remittance basis or the treaty benefits. The last point I wanted to touch on is very much the old estate duty treaty between India and the UK. So this treaty from 1956 is very powerful for those residing in the UK long term. And the reason this is very important is that, as I've mentioned earlier in the session, after year 15, an individual is considered to be deemed domiciled for all tax purposes. So that's for all heads of taxation, being income tax, capital gains tax, and quite importantly, inheritance tax. If I have a scenario where unfortunately, a family didn't know about the opportunity to use a trust structure, but they have beneficiaries in the UK that have been resident here long term, so more than 15 years, there may still be an opportunity to plan for assets that they hold or inherit, and those assets stay outside of the UK. And that's relying on the India-UK Old Estate Duty Treaty. Now, this treaty essentially means that those that are of Indian origin and considered by Indian law to be domiciled in India, if they have assets outside of the UK that pass under a non-UK will, then those assets can remain outside of the scope of UK inheritance tax. Now, this is obviously a game changer to some extent, because it means that there's a real planning opportunity for those of Indian origin. And that's where I believe it was Varsha that touched on the domicile of origin being very topical. And in this context, I often come across families who have migrated to East Africa, to South Africa, but their father was originally from India, and subsequently grandchildren have moved to the UK. In this context, we often seek to get an Indian opinion on the domicile of origin of the father who was the economic migrant to East Africa, for instance, to really understand whether that individual retained their Indian domicile of origin, and therefore grandchildren who are actually in the UK may still have a domicile of origin of India as opposed to that of East Africa. And this is a sort of opportunity for those of Indian origin, as I've said, and it's one where if you've got the right advice in place, you could really see a different scenario in terms of the taxation from an inheritance tax perspective in the UK. So it's very important to have a non-UK will to provide for those assets, but it is possible to really essentially plan for those types of assets in a tax efficient way. In terms of concluding thoughts on relocation and succession from a do's and don'ts perspective sort of thing, one thing I would say is that because of the capital controls that Shipra discussed and the residency from a FEMA perspective as well as a tax perspective, I think it's really important to seek advice about whether you might seek to gift assets between spouses or to children, or to establish trust structures of which individuals will become beneficiaries. Because once an individual does become non-FEMA resident and one family member is still subject to the LRS limits, they forever will remain subject to those LRS limits for gifting assets to other family members. And that becomes quite prohibitive if a family is looking to really diversify asset bases and send assets outside of India. Another context to be careful around is trust distributions. As I identified, it's the beneficiary that's taxable on a distribution as opposed to the trust from a UK standpoint. And therefore, if you're going to look at making distributions from a trust to fund education in the UK, for instance, when that distribution is subsequently brought to the UK would still seek to tax that distribution and match against relevant income and gains, and then we could fall into the pitfall of the tax credit mismatch. In terms of opportunities, I would say that, as I sort of identified, there is a real opportunity for those that are seeking to have an environment that is quite tax friendly for non-UK source income and gains, and that's availing themselves of a remittance basis. So where families take pre-arrival advice and really establish something called clean capital, which is quite specific and technical in a way, but we have worked with financial institutions based in India that can really look to protect clean capital and not taint it. Then there is a real opportunity to fund lifestyle in the UK in a tax efficient way. The other that we do come across typically as a opportunity or a problem is with regards to purchasing UK residential property once someone's become tax resident. And the real issue there is funding that deposit for the property, and you want to make sure that you've identified routes of establishing clean capital in order to be able to fund that property purchase. So I would say that there's a lot of tax efficiency that can be achieved if the planning is done correctly, but it really would rely on India and UK advice working in tandem to really identify how family structures could potentially be restructured to provide for tax efficiencies. Thank you. I'll pass back to Varsha.
Thanks, Hetal. That was super interesting. Shipra, I'm going to jump back to you. Any final thoughts on just structuring aspects and some particular trust-related aspects in the resident and non-resident scenario that we need to keep in mind in India?
Sure. So I'll just jump back to the examples that the case study that Hetal was referring to, just sort of playing around that case study. I think, like Hetal mentioned, there is a difference in terms of how trust taxation works in India versus how it works in the US. Unlike the UK, in India, there is no deferral of income per se, in the sense that in case of a Indian trust, as soon as a trust makes income, you would pay taxes on that. Having said that, there are certain opportunities for structuring available depending upon the trust structure. For example, if we are looking at, say, an offshore Guernsey trust, which has, say, a UK beneficiary and which also has an India beneficiary. So as a discretionary trust, the trust is going to be taxed from an India tax perspective at the trustee level itself. However, here, if the trustee is, of course, outside of India, the trust is controlled and managed outside of India, India can, as such, not really extend a right to tax the trust's income. The second aspect is, of course, that the trust has both resident and non-resident beneficiaries. It is a discretionary trust, which would mean that the trustee has discretion. It has even the full discretion to, say, provide for all trust income to be distributed to the non-resident beneficiaries. So that's also another argument that can be taken to sort of get around in Indian taxation, and to take the stand that only upon distributions made to an Indian beneficiary can Indian taxes really apply. So I think this is one interesting structure where a sort of a tax deferral can be achieved in a trust scenario. And I think lastly, like Hetal mentioned, apart from tax issues, exchange control issues become really important from an India perspective. I think 2 or 3 things that we already discussed. One is, of course, there are limits on, there are LRS limits of 250,000 as to the money you can send out through to your foreign bank account as an Indian resident. So it's only up to that limit. So if you're looking at, say, settling or having a foreign trust abroad for making foreign investments, that's your limit. In case of NRIs who have been resident in the past, there is a concept of NRO account which we discussed, where the limit on remittance is slightly higher. So that's just something to keep in mind if for NRIs who have sort of settled abroad at this point in time. So that's another sort of mechanism of repatriating funds from India. So I think those were 2 or 3 things I think that global families migrating from India probably do need to keep in mind. Varsha, over to you for any concluding thoughts, and of course, Nishith Bhai's thoughts on this.
Yeah.
Thanks, Chipra. Nishith Bhai, going to call upon you now. We've had an engaging hour with both Chipra and Hetal telling us what families need to keep in mind when they're migrating to the UK, or who already stay in the UK. Would love to hear your thoughts and experiences on these.
I think a couple of things maybe I can add on here at this point in time. One, there has been a question about the trustees holding assets in India legally and beneficially. See, the concept basically is that while we have borrowed common law concepts for the trust in India, India has a codified trust law, by the way. Okay, and under which essentially the trustee is the legal and beneficial owner of the trust assets. Beneficiaries have beneficial interest, not the ownership. So the word ownership has its own connotation, right to hold, dispose of these, that, etc. Typically, only for tax purposes, it is considered as a pass-through if it is a specific trust. This is just to clarify, and that, so there are legal issues more than the tax issues as well. Second point I thought would be useful for people to know is in relation to holding of immovable property in the UK. I don't know if you had a chance to discuss much on that, but I understand that to hold a UK property, you have 2 ways to do. You either hold individually, and in that case, if something happens, then you have to suffer inheritance tax, which is about 40% or so. Whereas if you hold it through a non-UK entity, then like company, for example, then you can avoid that because the property doesn't get transferred on that. It's only the shares which are located outside the UK. But I believe that you have to pay about 14% stamp duty at the time of purchase of the property. Correct me if I'm wrong.
Right. So that was a very common planning tool previously, to use offshore trust structures or company structures to own UK residential property. Unfortunately, the rules did significantly change. So even if you have a non-UK company owning UK residential property, essentially the company becomes transparent now, and it will be in the scope of inheritance tax in the UK. So any trust structures and company structures that previously could afford a lot of benefits from an inheritance tax perspective for holding UK residential property have been eroded away, unfortunately.
Right. So, but the stamp duty still remains 14% for the
15% for company ownership versus.
If something happens, a non-resident holding foreign company shares, if something happens to him, then this is like equivalent of the US the FERPTA, the foreign.
Essentially, it's in the scope of inheritance tax.
So it would still be subject to inheritance tax, even though it's. So one,
So
I have to be very careful about.
opportunities, yeah. So the opportunities in terms of really decreasing inheritance tax exposure when owning UK residential property is now more focused on leverage, so acquiring debt at the time of the purchase, which is considered deductible debt for the purposes of the estate for inheritance tax purposes, or shared ownership. So what we principally look at as a planning tool is possibly owning a property amongst various family members, which can sometimes work quite nicely with using multiple family members LRS from an India perspective. But that's really the only effective ways of mitigating inheritance tax now. A lot of, I'd say, a lot of company structures were de-enveloped after a tax came in called ATED, which also seeks to tax any companies owning residential property that is available to a family for their own use. So if a company owns a property and it's available for the family to use, there is a one-off charge every year, which essentially penalizes those families that are owning properties through corporate structures.
And if there is a potential exposure, can you tell something about insurance available? I remember when we had estate duty in India, we used to buy insurance for payment of the,
Absolutely.
duty. And you have any idea about what kind of premium or how it works, something of that nature?
Typically in the UK, the best planning tool, and sorry, this is absolutely another option, is the insurance option, is a joint life second death policy, because spousal transfers on death are exempt from inheritance tax. So husband and wife owning a property, if something was to happen to husband and wife inherits, at that point, there's no inheritance tax. But then on the second death, policy could pay out. And what this could mean is that the beneficiaries of the estate may not need to then sell the property to pay the inheritance tax, which is a common problem in the UK. That often, from a liquidity perspective, in order to pay the inheritance tax, families sometimes, especially if there's not numerous properties and mostly illiquid assets, they sometimes have to dispose of properties in order to pay the inheritance tax.
So,
That's how
as you
insurance
mentioned,
works.
so better way is to have a foreign discretionary trust settled by a non-resident settler, and mainly for non-resident beneficiaries to own the UK property, then holding a company and owning UK property.
So again, essentially a non-UK trust that owns residential property will now be considered a relevant property trust, and though it won't be exposed to the 40% inheritance tax, it's exposed to a form of inheritance tax, which is essentially a 6% charge every 10 years. It's called the 10-year anniversary charge, which is essentially 6% of the market value every 10 years. And there would be an exit charge as well, which is not dissimilar. There's a complex calculation of how the percentage is calculated, but essentially, as say, what did work before from a trust structure or a company perspective, there are some disadvantages now, but on a case-by-case basis, you might find some structures are still effective. So we can sort of weigh up the pros and cons on an individual case-by-case basis.
So I think those are the questions, but I don't know if Varsha or Shipra want to take. I think they have been responding to the questions which have been coming in large numbers, and I don't think we already crossed our time. But anything is there? Maybe we can have some more comments, or please proceed as you deem appropriate.
Sure, Nishith bhai. We're beyond our time, and I think we've completed the points that we had intended to touch upon in this session. Hetal, this has been incredibly instructive and very useful to us also to understand, particularly when you put the laws side by side, you're able to identify very clearly where the points of departure are, and also identify those points to understand where it's very important for individuals to plan around. Thank you so much for helping us out with that today. It's been really nice listening to you. Shipra, thank you for presenting the Indian side of things, and it's been very interesting to hear the both of you and also to assess the case studies that you had put up. Nishith Bhai, thank you as always for your comments. Your experience brings a lot to the table, and obviously invaluable input in this session as well.
Thank you so much. In fact, I think some point in time we didn't have chance to discuss the probate issues and because those are not tax issues and they really matter, you know. And whether one should have two wheels or single wheel and all those kind of things exist. So I think some other point of time, I think we'll all have a discussion on that. But I hope this is enough to digest for this evening. I know you all have very strong appetite, all the audience I'm talking to, for knowledge and learning, but I think we'll stop at this point in time. So thank you so much, really coming in so many large numbers today. And once again, Hetal, thank you for making special effort to be with us this evening.
Thank you so much. It was lovely to participate and really interesting discussion. So thank you so much for having me.
Thank you.
Thank you. Thanks, Hetal.